Appeal Number 80, the people of the state of New York versus David Lofton.
Brian Schifrin on behalf of David Lofton. May I reserve 2 minutes for rebuttal, please?
You may.
Thank you. Before addressing the youthful offender point, I'd like to first urge that it was constitutional error for the district attorney to be twice permitted to argue in summation that the prosecution's case was undisputed, unchallenged, and uncontested. This was a case in which Mr. Lofton exercised his right to remain silent and attacked the prosecution's case through cross-examination.
If it's error, is it subject to harmless error analysis?
It's subject to constitutional harmless error because the nature of the error is that it went to the right of the defendant to remain silent and the burden of proof. Under the constitutional harmless error test of harmless beyond a reasonable doubt, the test, there is a reasonable possibility here that the offensive comments, especially because they were given the judicial sanction, made an impact. This is a case where, contrary...
Counsel, didn't the judge also instruct the jury that the burden never shifts?
He instructed the burden never shifts, but the judge's instruction after denying the second objection actually worsened the situation, because the judge said that, and set forth in both our briefs and the record, is the ruling is based upon the opportunity given to challenge the defendant's attorney to challenge the evidence, suggesting that the defendant did not in fact challenge the evidence. Instead, in this case, in detail, in summation, the defense counsel pointed out all the problems with the evidence, which resulted in acquittal of 2 of the 4 counts. This was a case in which the jury did not accept the complainant's testimony. We know that because if they accepted her testimony, there would have been a conviction of all 4 counts.
Would it have been fair comment on the evidence where the defendant was making and proffering a view of the case that no evidence was presented to support?
Respectfully, no, Your Honor. There was a statement on page 8291, appendix 291, saying that there was a criminal trespass here, and that's not challenged, Professor. That's not challenged. And they then immediately...
No, but he was arguing that there was a previous relationship, it was consensual, and so on and so forth. And so could that not have been a fair response to that theory?
It's actually... that actually highlighted the problem, because the 2 counts in which there were acquittal were the counts where the physical evidence didn't back up the complainant's allegations. The counts in which there were conviction were the counts in which the argument, based again in summation on the lack of evidence, based on her appearance, based on the failure to show anything in disarray, was that this was consensual behavior, and therefore it was a criminal trespass, but not a sexual count, and therefore not a burglary. That argument that it was consensual was effectively negated by the court's instruction that he had an opportunity to challenge on cross-examination, and it didn't do so. So it's our position that the court's instruction actually worsened the harm of that argument. Not made once, but made. First of all, the DA made it 3 times. The first time, objection sustained. Repeated 2 more times, and then after the second time the objection was overruled, the district attorney again said undisputed. So the message here was undisputed, unchallenged, and uncontroverted, and that is an improper argument, and we believe in a case where the jury had problems with the complainant's testimony, we don't believe it was harmless. Moving back to point 1, this is a case, it was a 15-year-old convicted of an enumerated sex offense. This case, court in Middlebrooks made it clear that in such cases, two determinations are required. 1, there has to be an on-the-record determination as to whether the statutory factors for the exceptions to allow youthful offender eligibility were met, and if so, a second determination as to whether or not the defendant should be adjudicated a youthful offender. In this case, when the defense counsel made a request for adjudication of YO as recommended by the PSI report, the court's only response is that is certainly outside the realm of this court's consideration following trial. That cannot meet the Middlebrooks requirement.
It wasn't in a context, though, that was a little bit broader than that. Weren't the court's remarks in a larger context, Mr. Schiffer?
The court had just explained, this was, again, I believe it's page 295 of the record.
Go ahead.
Of the record. The court had just explained why the court was imposing consecutive maximum sentences. However, you cannot tell from that statement by the court that it's not under consideration whether or not there was a refusal to consider YO, whether or not there was it was the determination that Mr. Lofton was eligible for YO treatment, or whether or not there was a determination he was eligible but not giving YO.
What should he have done? What should the judge have done? Gone through every single factor? What is it that you're saying is the rule?
The rule has to be that the record has to be sufficient to tell what was decided and why, which doesn't require enumeration of all the factors. I find you're not eligible because the statutory factors were not met would be sufficient.
Well, determination might mean result or it might mean explanation, and how do we know which it is here?
Indeed, that's the
So we
problem.
know the
I should
result,
point
right?
out this was a pre-Middlebrooks, pre-Rudolph case, which perhaps explains why the judge didn't do what Middlebrooks says. 3 times this court in Middlebrooks said you need an on-the-record statement as to whether or not the statutory exceptions were met. That wasn't done here.
So, you know that usually the Court of Appeals is very reluctant to require a litany by trial judges. It seems, though, that that's what you're asking for, some particular catechism that he has to
I
recite.
want to be clear that if I've given that impression, that's not what I'm urging. I'm not arguing there has to be a detailed analysis of each factor, but there has to be enough. There has to be enough to tell, first of all, in a case with a section where a person is
Would
convicted.
it be enough to just say, I have considered the factors under the statute, and I've determined that defendant is not eligible
Absolutely.
for YO?
Because then when I say we, both the attorneys at the trial level court and then the courts, appellate courts making review to determine whether an abuse of discretion can know what was decided and why. And that I believe
But is there really any view of this record that suggests that the judge didn't consider the absence of mitigating circumstances?
his language
as
saying it's
described in his characterization of the case and what he thought of these acts?
Respectfully, the judge's words, as beyond the court's consideration, suggest that he didn't consider it. The
What he
literal
said- what he
meaning
said
of the
right-
judge's words.
What he said right before that were, the trial evidence completely controverts the statements made by the defendant at the probation department. The defendant continues to deny any involvement whatsoever regarding sexual contact with the victim, again, totally inconsistent, contrary to what the jury ultimately determined. There was overwhelming evidence of the defendant as to the sexual acts that were performed upon the victim. Defendant engaged in what I deem to be some of the most vicious and blatant criminal behavior by an individual who is only 16 years of age at the present time. The trial evidence brought home to the court the very violent and vicious nature of the conduct of the defendant, and the probation report concluded that the defendant posed a threat to society. Those are the things he said right before saying, and youthful offender status is out of the question.
Okay. And just so it's clear, everything that you just said was said with respect to why the judge was imposing the sentence that he imposed. The court then said, and additionally, then it goes to there was a request for PSI, for youthful offender adjudication. If the judge said, and for the reasons I just stated, I determined he's not eligible, done.
So those reasons are sufficient if he had tied it to the youthful
Yeah, and it
offender
wasn't tied to the issue of YO. It was tied to the imposition of the particular sentence.
So, counsel, this is a case before Middlebrook where we hadn't said yet, I think it's 4 years before Middlebrook, we hadn't said yet you need to do this, with reference to these factors, I would find they don't apply. And following up on what Judge Wilson said, it seems this record is more robust as to why they don't apply. So we would be sending a case back at this point to give the opportunity for the judge, based on essentially those same findings, to put in the record, and I don't find those 2 factors apply, one of which is role in the offense, which clearly doesn't apply here. So it's only mitigating. He went through that litany, 4 years before Middlebrook, and now we're going to send it back so he can say, and because of those same reasons, I don't think he's a youthful offender.
Again, not criticizing the judge for not anticipating Middlebrooks. In Middlebrooks, this court rejected the contention that the burden is on the defendant to show the exceptions were met, but rather said in every case it's required. It wasn't done here. This is a case on direct appeal.
But if they're the same factors he just went through and didn't say those are the reasons why under the mitigating prong he doesn't qualify, but
agree.
says he doesn't qualify as a youthful offender, I don't know what we would be sending it back.
We're sending it back to ensure that there's not a new exception to Middlebrook, which is not going to only affect Mr. Lofton, but many other defendants, which is, well, if we know he's not going to get it, it doesn't matter. That Middlebrooks is an easy thing to do. The requirement is very simple. It takes less than a minute to do.
But as I
It
remember
wasn't done
Middlebrooks,
here.
no one mentioned youthful offender and there was no discussion of it.
But the holding, is not merely you can't discuss it. It says 3 separate times there must be on the record determination of the statutory factors. Not done here.
Well, this was also before Rudolph, too, wasn't it?
That's correct, Your Honor.
Thank you, Mr. Schifrin. Counsel?
Good afternoon, Your Honor. Scott Miles on behalf of the people. Very briefly touching on appellant's arguments in regards to the people's summation. You cannot look at the people's summation in a vacuum. You have to also look at the defendant's summation, which happened immediately before the people's closing arguments, in which the defense counsel himself reiterated several times that they were not challenging certain of the allegations. He used the word, you'll find that the certain allegations unchallenged. So the fact that the people in their summation then went ahead and agreed with the defense that there were no challenges to certain of the allegations, there's no error there. If there was any kind of error, it was ameliorated by the judge's instructions to the jury that the burden never shifts from the people to the defendant. In addition, if there was any error, it would have been harmless given the overwhelming nature of the evidence in this case. Moving on to the youthful offender issue. I would like to note in regards to what Judge Garcia was just saying, there has never been any argument at any point in this case at the lower appellate division or before this court that in fact this defendant is eligible for youthful offender. There has never been.
But didn't Middlebrook say that the court had to make that determination on the record? Isn't that what Middlebrook stands for?
It does, Your Honor. And
what does that mean?
I think that's exactly what we're here for. We're here to determine once and for all what is meant by that word determination. What constitutes a determination on the record?
Is it enough to just say, I'm sentencing you to X, which happens to be the maximum sentence allowable because of all of these factors? Is that enough to indicate that the court considered YO status and rejected it?
I think just a simple statement of what the sentence is after Middlebrooks would not be enough. I think there has to be some indication on the record that the judge is considering those factors in relation to the youthful offender statute.
And where does that exist in this discussion?
When the judge states in a single unbroken, I believe it's 1 or 2 paragraphs, where the judge goes through not mitigating factors that he found in this case, but in fact aggravating factors. He uses the phrase vicious conduct.
How do we know from that he didn't think that the defendant was legally eligible? How do we know?
I think given the fact that he goes through all of the factors that weighed on his decision and then immediately after that says, based on all that proof that came in at trial, youthful offender, he doesn't use the phrase youthful offender, but he's clearly referencing youthful offender. That is beyond this court's, that is something that the court is not going to consider for you.
Well, it's beyond, yeah. That's the problem that I'm having, is that there are several ways that could be interpreted, and if it's not a clear statement, is that enough?
Again, as the people put in their papers, in this case, it is enough, because it's clear that the court made a determination. It determined that this defendant was not going to be receiving youthful offender treatment. And immediately before making that determination, it went through all of the reasons, all of the factors.
Well, but then what is, I'm sorry, I have to go back. Then what does Middlebrooks mean? If it's enough that the court doesn't give YO treatment to satisfy Middlebrooks, what did Middlebrooks add to the discussion? I thought that's what Middlebrooks was correcting. It was saying that isn't enough.
I think that's exactly what we're doing here, Your Honor. Either myself and the Fourth Department or the appellant is not understanding what Middlebrooks said. So the appellant is urging this court to adopt a rule that the court, the sentencing court, does not merely need to make a determination, but it needs to state the reasons for its determination.
I think that's a separate issue. I'm not even getting to that issue. I'm just trying to determine whether the court said enough to tell us that it made a determination, as opposed to made some assumptions and just went on to sentence without YO.
Well, again, I think that's getting us, again, to the argument of a litany that is required, a specific set of words that the sentencing court needs to say in order to make it clear whether or not a determination is being made. And again, that gets us back to what is meant by the word determination. Is a simple yes or no in the context of whether youthful offender is going to be granted, is that a determination?
So put aside for a moment the things that I read that the judge said during the colloquy, and pretend he hadn't said them, but all that he said were these words, which he actually did say. The request that defendant be adjudicated a youthful offender is certainly outside the realm of this court's consideration following trial. If he said just that, does that satisfy Middlebrooks or no?
I would say that it does, because again, that is a determination. That is saying, I have considered youthful offender in the context of this defendant, and I am not granting it. And again, Middlebrooks went through
Well, the problem you have is that Middlebrooks was dealing with a situation where you've got someone who's not an eligible youth because they're convicted of an armed felony or a designated sex offense. So that's what this defendant falls into this category. Let me just finish the thought. So then the question is, the court needs to make a determination. First, is this person an eligible youth? Then secondly, do the mitigating factors under, what is it, 720.10.3 apply? That would be the normal process. You'd have a two-step process. Is he eligible? Do the yes or no, no, and if yes, then do these mitigating factors apply to this person? Will we grant him YO status? That clearly wasn't done here, but this is pre-Rudolph, pre-Middlebrook, so is the language sufficient, I guess, is the question. And where is there two separate determinations in there that you can point to in the record?
I can't point to any two separate discrete points in the record, because again, it is essentially one unbroken thought process by the judge. Right. I would just note that Middlebrooks and Rudolph also dealt with a situation where the sentencing court was silent as to youthful offender. That is not what happens here. In Middlebrooks, this court determined that as a policy consideration for why it was deciding Middlebrooks the way that it did, that the youthful offender adjudication is so important to certain defendants that there needs to be some
Well, it's
indication.
also based on the statutory language, right?
Correct, yes.
Yeah, so it's not just policy there.
No, but there was policy discussion.
Let's say we disagree with what you argue is the clarity of the words of the judge. So if it's uncertain or ambiguous, doesn't that then, under Middlebrooks and under the statute, require that it go back for resentencing to get that clarity?
I don't believe it would, Your Honor, because the wording of the statute, in my view, says that a defendant is not eligible unless the judge determines, based on one of those two factors, that he is in fact eligible. That clearly did not happen here. So the judge's determination that he was not granting the defendant youthful offender, after stating all of the aggravating factors that he found after hearing the proof at trial, it's people's position that that satisfies the requirements of Middlebrooks.
Thank you, counsel. Counsel?
First,
Mr. Schifrin, can you jump to that point that counsel just made at the end, where basically you could tell by reading what the judge said that he thought that this defendant was eligible, and the only question is whether or not he was going to grant it. That's the way I understand that argument.
this is a case in which no one, neither attorney nor the judge even mentioned it was a conviction for an enumerated sex offense. It's not in the PSI report. It's speculation that this judge even was considering the fact that it might
Are you
not have been.
familiar with Stitt, the Fourth Department case?
Yes, Stitt's different in a few respects, because in Stitt, the Fourth Department went through its ruling as to why it wasn't granting YO, or it considered the factors, and therefore necessarily had got past eligibility. Because you can't go through the factors for weighing without having determined he's eligible.
I got
In this case, there wasn't, this is, to me, actually I cite Stitt because I think Stitt shows there was not a lot required to get to the Middlebrook test, and yet that wasn't done here. There was simply impossible to read this record and know for sure that the judge even considered the possibility of YO, consider the issue of eligibility for the enumerated sex offense exceptions, or determine YO. But again, with respect to the summation issue, counsel just argued that this was a proper response to the summation, because the argument was the trial prosecutor argued that it was not challenged with respect to certain allegations. Respectfully, that was not the argument made below. The district attorney repeatedly said unchallenged, undisputed, uncontroverted with respect to all the allegations. The only thing that the defense attorney said was unchallenged was that criminal trespass and that there had been an act of anal sex, but the argument was that was consensual. And therefore, to use that as a basis for saying invited comment is simply improper. Thank you, Your Honors.
Thank you, counsel.